All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in State against Johnson. Our cause number is 1CA CV210060. Counsel, I'm sure you're familiar with the general process here. The appellant, each side has 20 minutes, and the appellant may reserve as much time as you wish for oral arguments, subject to watching your own clock. As you'll see, for social distancing purposes, we've placed podiums at each of the tables. So if you'd argue from that point, we'd appreciate it. Mask usage is obviously up to you, given the social distancing measures. And if that, we may begin.
And if I may, I would like to reserve 5 minutes for rebuttal. May it please the Court, my name is Alexa Gervasi, and I'm here on behalf of claimant appellant Jerry Johnson. Under Arizona's forfeiture statute, probable cause hearings must proceed in two discrete steps. Step 1, the standing inquiry. Stop. Step 2, the probable cause inquiry. Stop. Here, the Superior Court improperly conflated these two inquiries into a single step. And in doing so, it shifted the burden to Jerry and relieved the government of its burden to prove that Jerry's property was subject to forfeiture by clear and convincing evidence. Specifically, the Superior Court held that Jerry did not have standing to challenge the seizure of the cash that was seized directly from his person, because in the court's view, it was more likely that Jerry was engaged in criminal activity. Under 1343-10D...
Counsel, just for a second, I'd like to ask you a hypothetical. If we have a drug mule that is transporting money, drug proceeds, does the mule own the money that he or she is transporting?
It depends, Your Honor. It depends on if the money is the quote-unquote mule, the person carrying the cash. So, for instance, if it were the person's drugs, and then they sold those drugs, and that was, in fact, their money, they would have standing to challenge the forfeiture of those assets. Now, of course, at the merit stage, they may not be successful, but the point is that they would have standing to proceed.
So the key in your response, I'm assuming that's not a mule in the sense that that person is actually the recipient of the cash. I'm talking about the pure innocent mule who just takes a package, flies, from Philadelphia to Arizona, and has $40,000 in his or her bag.
That is correct, Your Honor. If somebody were just carrying a package that did not belong to them, that was somebody else's, they would not have standing to challenge the forfeiture of those assets. But here, that is...
So is Judge Warner's comments in this case, is it an indication that he may have believed that the evidence proved that Mr. Johnson was, in fact, that mule?
No, Your Honor. When we look at the court's order, that is not what the court found. What the court found was that it was more likely than not that Jerry was engaged in criminal activity. But that is not the proper question at the standing stage.
Well, counsel, I'm just reading from the order. It says, or that Johnson was transporting the proceeds of drug transactions. And then he says the latter is more likely. Is that what he said, or did he say that it was connected to criminal activity?
Your Honor, the court said proceeds of a drug transaction, but the court never found that those proceeds were not Jerry's. So, for instance, Your Honors, proceeds of drug transactions can still be Jerry's property. So even if Jerry were involved in criminal activity, which he was not, that's not the question. The question is whether or not the money was Jerry's. And when we look at the court's order, it's clear that the court was concerned with indicia of criminal activity, not the ownership inquiry itself. In fact, the majority of the findings the court made are entirely irrelevant to the standing inquiry at all. And Your Honors, when we look at the transcript from the court hearing, it is clear that the court twice found that Jerry was the owner of the property. For instance, after receiving the direct testimony of Jerry, the court said, at this point, your only burden is to establish an interest in the property. He's testified that the cash was his, and I think that's sufficient. And then after cross-examination, the court said, you clearly established his interest in the property, so I don't think you need to put on additional evidence. So when we compare those statements against the court's order, which discusses almost exclusively indicia of criminal activity, not ownership, it's clear that the court was adding an additional burden into 4310D's standing inquiry. The court was concerned with whether or not the source of Jerry's funds was innocent, was disconnected from criminal activity. And adding in that extra burden onto Jerry was legal error, which requires this court to vacate the lower court's order.
Well, counsel, and just to play devil's advocate here, but the way I read it is there were two different versions of evidence that were presented. One of the versions was your client's testimony that I was going to buy a truck, I got a loan for part of it, the rest are mine, here are my tax records that show how I got the money, blah, 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 blah. Judge, after hearing all of the evidence, Judge Warner says, I don't buy that. I don't buy it. It's more likely that this was proceeds from a drug transaction. But doesn't that go back to the mule argument? Was Judge Warner saying at that moment, this is mule money, and since you've said, given me a different version, I'm going to find that this is mule money and you were transporting mule money, and you just told me that in that scenario, that person doesn't have ownership.
Your Honor, what you've pointed out is you've identified an ambiguity in the court's ruling that you're saying that maybe perhaps one way we could read it is that he is acting as a mule. And if that ambiguity is what this court's finding, then it still must remand for another forfeiture proceeding. Because even under that rule, there's not a clear ruling about whether or not Jerry is the owner. The court did not say that Jerry was a drug mule. The court did not find that the money was not Jerry's. The court improperly looked to indicia of criminal activity to conclude that it was more likely than not that Jerry was engaged in criminal activity, and for that reason was not the owner. And, Your Honors, we know this because we know what the test is for establishing an ownership interest. In both Volstrom and Benson, Arizona courts have said that the standing inquiry is a low bar. Where a claimant makes 3 showings, he has satisfied his burden. First, that he timely filed a sworn claim. Second, that the money was taken directly from his person. And third, that there are no other claimants. Jerry satisfied each of these showings, and the government did not contest them. There was no question about the veracity of Jerry's claim. The money was indisputably taken directly from Jerry's person, and the government did not even suggest that there is somebody else who could own the money. So under this test, it is clear that Jerry satisfied his burden. It was only because the court added an additional element into the test, which was legal error, that it found that Jerry was not the owner.
I have actually fairly little trouble with the notion that your client established ownership. I mean, the state all but conceded it at the beginning, the trial court all but accepted it, and as you say, the boxes were checked. But help us untie the knot. Let's assume that standing was established. Has the court not already then heard sufficient evidence of probable cause to warrant the forfeiture?
Absolutely not, Your Honor.
Okay.
The probable cause inquiry, the only question asked at a probable cause hearing is who's going to hold on to the money while the proceedings continue. So even if the government did satisfy probable cause, the only question would be who would have possession of the money while the forfeiture proceedings continue. The burden is on the government to show by clear and convincing evidence that the property is subject to forfeiture. That merits hearing has not yet occurred, and so that is why this court must remand for those additional forfeiture proceedings, where the government is certainly entitled to try to show by clear and convincing evidence that the money is subject to forfeiture. But at the proceeding that happened here, that was, first of all, not the question before the court, because the only question was whether or not there was probable cause, so who was going to retain the money in the meantime. And because of the proceedings in the court, Jerry was not given the opportunity to challenge any clear and convincing evidence on the merits of the forfeiture. And so for that reason, this court must still remand for further forfeiture proceedings. And Your Honors, Judge McMurray, you asked about the evidence that was received, which, Your Honor, went to probable cause. And the important thing about the evidence that the government put on and that later influenced the court's reasoning in its holding is that this was evidence that was not properly before the court. Under Section 4310D, the standing inquiry must first be satisfied, and the judge must issue a ruling on standing before it can receive evidence of probable cause. So even if there were evidence of probable cause before the court that influenced its standing ruling, this is also legal error that the court could not receive this evidence.
You're not suggesting the court has to have two hearings. Why can't you just have a combined hearing as long as the court compartmentalizes the evidence?
Your Honor, 4310D does not allow for that type of proceeding. What 4310D expressly says is that the claimant must establish by a preponderance of the evidence that he is an old owner or interest holder in the property seized for forfeiture, quote, before other evidence is taken, end quote. So, Your Honor, this is not to say that the government must then put the standing evidence back on again a second time if that standing evidence speaks to probable cause. But what the government may not do is they may not provide probable cause evidence during the standing stage of the proceeding. And
Counsel, what if the evidence is okay, so we have owner is defined by the statute and excludes an agent or what we've been saying is a mule. If evidence is presented that Jerry was a mule, that would seem to hit both categories, ownership and probable cause. Do you agree with that?
Your Honor, if there were evidence presented that spoke both to standing and to probable cause, that evidence could absolutely come in during the standing stage and then be referred back to during the probable cause stage. But what cannot happen is the government may not present evidence of probable cause and just probable cause during the standing inquiry before the standing inquiry is concluded. And that is what happened here. And we know that that's what happened here because that's exactly what the government asked the court to do. On page 38 of the transcript, the government said, I would appreciate if you'd reserve ruling because I'd like to be able to give you the probable cause part 2. And so evidence of both type were presented during the standing inquiry and they were not parsed out. So to the question of whether or not they can compartmentalize, that would be fine, of course, if the standing evidence went both the standing and probable cause. But when we look to the court's order, it is clear that the probable cause evidence and evidence just of probable cause infected the court's opinion. When we look at the court's findings of fact, the vast majority of them speak only to indicia of criminal activity, or they're entirely irrelevant to the question of ownership altogether. And so that is how we know that the court did not hear only standing evidence and then make a ruling based on standing, but allowed this probable cause evidence, which under 4310D it was not allowed to receive, and then allowed that evidence to infect its ruling, leading to its conclusion that because it was more likely that Jerry was not, that Jerry was engaged in criminal activity during his travels, he was not an owner of the property. And I see that I have about 5 minutes remaining, and I'd like to reserve that time for rebuttal.
Of course, thank you very much.
My name is Dallin Gardner. I work for the Maricopa County Attorney's Office. And on behalf of the state, we do believe that the judge did compartmentalize the issues. I don't think anything could be more clear than that that's what he did, because you look at the hearing itself, he was taking the evidence, and initially, before the state had even cross-examined or had presented any evidence, he was initially keeping these two issues separate, saying, oh, I think you've already presented sufficient evidence. So he was totally aware that these are two distinct issues. The defense, or the state, needed to be able to cross-examine and need to present more evidence, and when the state did that, then he found that he hadn't met his burden. And when you look at the ruling itself, you have the same thing.
Let me ask you, do you think he met his burden? Does he own the money?
No.
So he doesn't have standing?
He doesn't have standing.
Why not?
Because
Who else owns it?
We don't know who owns it. I wish we could have known if it were from him.
Well, hold on. Well, you're talking preponderance of the evidence. And if you don't know anybody else owns this money, and he says, I own it, then that's by definition preponderance of the evidence.
We showed a lot of factors that show he's not in fact the owner. That's what we showed.
What evidence did you show to that effect?
So you first start out that this guy has a business, he files tax returns, he has a bank account, he uses
By
banks.
this guy, you're speaking about the appellant?
Yes. I
Perhaps you
apologize.
could use more respectful language.
I'm sorry. I'm referring to the appellant. The appellant has these things. He's a business owner, files taxes, has a bank account, has a business bank account, says he came here for a business purpose to purchase a truck. When you start looking into that, okay, he has a business bank record. Where's where any business bank records? Well, he doesn't actually keep his money in the bank. He keeps it at home, in a closet. It's not locked up. There's
Okay, so you say this with a fairly dismissive tone, but what evidence do you have that he doesn't own the money?
I'm going to keep getting to that. So
I'm waiting.
first you want to look at what he's saying, because you're saying if he says it, then how can you refute it? So let's look into what he's saying.
No, I'm saying you can refute it if you can show the other ownership, but you didn't. There's no evidence in this record whatsoever that would indicate somebody else owned it.
Well, somebody owns it. I'm saying that
And he
evidence
says, I
shows-
did it, and nobody else could step forward.
Can you say that again?
He said, I owned it. And no other evidence, none, was presented to another ownership.
The state doesn't have to prove who the owner is. The state has to prove when it gets to its burden if the money's connected to drug trafficking. But at the beginning, the only people have...
Okay. Is that at the probable cause stage, or is that the final stage?
He has to establish... his
No,
burden.
please answer my question. The state's burden, is that at the probable cause stage, or is that at the final clear and convincing evidence stage?
If there's no claimant, it's at a probable cause standard. But if there is a claimant, then it's the clear and convincing.
Well, we haven't had a clear and convincing trial here, have we?
Well, but that's because there is no claimant that has standing. There's no owner.
Am I the only one that's, I'm having a circular argument here. He says, I own the money. Where is there contrary evidence that would indicate it's not him, but it's somebody else?
He doesn't know how much he has. There's one.
I don't know how much I have in my wallet. Do you need to check it? Should I be worried that the police are going to come check it? Am I going to have to explain where I got it?
As Judge Warner explained, any one of these factors I'm going to go into could be explained away, but when you look at the totality of it...
I actually asked you a question, and I'd like an answer. If I don't know how much money I have in my wallet, should I be worried when I walk out the courthouse door that the police are going to make me prove where I got it?
No.
Why? Why am I special?
Because that wasn't the only factor they were considering in this case with the appellant.
Okay, what other factors were they considering?
So he didn't know, he came with this large quantity of money, he doesn't know how much he has. He also doesn't use marijuana, he says, and it smells like marijuana. So you have this large bundle of money, he doesn't know how much he has.
You may remember that back in, I believe, the early 2000s, they did an analysis of the cash in our governor's wallet, and it was tainted with cocaine. Did that mean that she was a cocaine dealer, or did that mean that she had cash that had been in distribution?
It could have meant that there was cash in distribution.
It sure could have. I don't think anybody made her forfeit the money in her wallet.
I said there's lots of factors.
So the fact that it's very hard for me to imagine impregnating $40,000 with marijuana smell. So the fact that you say the money smelled like marijuana is were I sitting as finder of fact, highly unpersuasive.
So that was one factor. So
Okay, let's get to a good one.
Okay, I think they're good, but he doesn't know how much he has. He also smells like marijuana, yet he doesn't use marijuana. You also have the fact that
You know, Mr. Gardner, all of these things, and you can continue, but all of these things to me go to the issue of probable cause. They go to the issue of probable cause on whether or not he was engaged in bringing money, drug proceeds into this state. It doesn't go to ownership, because you can own ill-gotten gains. So in order for you to come forward with evidence that would indicate he didn't own the money, you would have to show that he is just a courier of the money. Do you have any evidence that would indicate that he was just the courier of this money?
And that's what I'm getting into. I think that's the evidence that he's a courier, is that the evidence presented by the detective was about the suspicious flight itineraries.
Agreed. Agreed. That goes to that issue.
I'm sorry, did anybody ever say courier, mule, or any similar thing at the hearing?
I mean, I'd have to go back and look.
I don't think that was the state's theory. I don't think the state ever advanced that theory. And if the evidence now you're saying is that that's what it shows, one would think somebody would have mentioned it.
The state's position from the beginning was this wasn't appellant's money. So that's why I was a little surprised when you said the state conceded it. Our position was not that appellant can't keep this money because it's drug proceeds. It's that this isn't his money at all. He doesn't have
So it must
standing.
be the state's then.
It belongs to a drug trafficker. He's a courier.
And
Well, nobody ever said this.
and that evidence was proven. I mean, that evidence was before the court, that he was just a courier. Because that's what it would have to have been. By a preponderance of the evidence, his statement, "I own it," is not enough.
That's right. Because there's different standards in establishing standing. At the beginning, when the claim stage, you only have to assert it. There's no rebuttal or anything. All you have to do is assert it. If you plead it the right way, then you've met standing and being. That's why we didn't contest it there. We contested the evidentiary hearing because there he has to actually establish it. And you can see Judge's ruling, Judge Warner, that he didn't establish it because what it came down to, the judge, was two possibilities. The state was never saying this innocent ownership requirement that, Judge, this is his drug proceeds. The state's position was that he's not the owner of these proceeds, and here's these reasons why. And when the court was considering this, it looked specifically into the two possibilities, that claimant flew with his own cash to buy a truck, or that he was transporting the proceeds of drug transactions.
But it didn't say, the court didn't say, and the state didn't say that he was transporting the proceeds of someone else's drug transactions. What the theme was we don't like where this money came from. But nobody ever suggested that somebody else owned it.
I said it wasn't his money. I mean, that was my whole point from the beginning. This isn't his money. And
You didn't say it was somebody else's?
Well, if it's not whose is it?
Well, apparently it's the state's.
We seized it because it's connected to drug trafficking, but I wasn't saying at the beginning it was our money.
So counsel, let's frame this. The standard is preponderance of the evidence. Is that right?
For the burden that he has.
For what we're here for today in the
Yes.
trial court, okay. And how do you interpret that? What is the preponderance of the evidence standard?
I guess 51 to 49.
Okay, and so we have the claimant coming forth saying this is my money, offering an affidavit or a declaration from an uncle, saying I lent him this money. And so that gets the claimant, I don't know, let's say that he's proven it, but then you have to come forward and make that less likely than more likely. And all you have is negative evidence. I mean, you have no one that says this is my money, or no communications to indicate that the money was directed or belonged to anyone. You're just coming with these almost detached factors that touch on probable cause to make your case on standing. Is that appropriate?
I think as you guys were going into earlier, that sometimes these factors can do both. And that's why we wanted to just, for judicial economy, present the evidence and the judge could weigh both of them, because some of the factors that undermine ownership also deal with the probable cause issue. So we presented both of them, and I thought the judge demonstrated that he compartmentalized. And I think what it comes down to is the judge...
Well, hold on, because what the judge found, or what the judge said, is I've been presented two theories. Theory one is he came here to buy a truck that I'm not buying. Theory two is he came here with drug proceeds money. But going back to what Judge Swan indicated and Judge Wansworth said, he didn't say or didn't find that the client, that Mr. Johnson, wasn't involved in the original drug transactions, generating the money, and that he didn't own it. He didn't say that. He didn't find that. He just said, I'm buying the second one, which would be probable cause, right? You read it.
Yeah, I think he said claimant is not an owner. I mean...
No. Read what he found. That's the conclusion.
Claimant has not met his burden of proof.
Again, that's a finding. Get to the conclusion. Get to the finding where he says there are two theories. Theory one, I'm rejecting, and theory two is
that he's transporting the proceeds of drug transactions.
All right. That he's transporting the drug proceeds. Does he find that he was not the recipient owner of those drug proceeds?
It's exactly what he says in the next sentence. He says, claimant has not met his burden of proving that he owns it. The court, therefore, does not reach the issue of probable cause because claimant is not an owner or interest holder. I mean, he specifically said he finds he's not an owner or interest holder.
He didn't specifically say that the claimant was transporting somebody else's money. He said that the claimant was transporting the proceeds of a drug transaction, which is a debatable conclusion, but nonetheless off point when it comes to asking whether it was the claimant's money or someone else's money. Judge Warner never articulated any suggestion that the money was someone else's. He articulated the suggestion and the finding that the money came from unlawful sources, and that's different.
He said that he said it's not yours, that I think it's more likely that you're transporting drug proceeds and that you're not the owner.
And what basis is there in the record? Do we have any indication who was making these drug transactions?
So it sounds like the burden is turning to the state to prove who the owner is. And that burden is not...
You didn't answer my question, because my question is what evidence would indicate otherwise, and you didn't answer that. You said you fell back on, it's not my burden. The burden is he says I owned it. However I got it, I owned it. And you want us to say that isn't a preponderance of evidence, going to what Judge Weinsberg said, then what evidence would indicate that somebody else did the drug transaction and they owned it? I don't care who presented the evidence, what evidence is in the record that would support such a conclusion?
That it's not his money.
That somebody else did the drug transaction and generated the proceeds.
That he was transporting the money as an agent for someone else.
But we don't know who the agent is.
Right. Negative evidence.
But that would mean all you'd have to do is get a money mule who's never going to disclose who the agent is, and boom, he says it's his, and you're stuck. Because in this case, we even asked him about who he was wiring.
I'm sorry if it seems harsh that the state should actually have to come forward with evidence before it takes people's money away at the airport. But that's the law. And the law, I will note, the law has evolved since this case, and the legislature fixed what is a very distasteful process. But under the old statute, the state does bear the burden. Once the claimant meets a burden of production, which I think was amply met here, the state bears the burden of refuting that burden of production. And the state did not present, as far as I can tell, one scintilla of evidence that the money belonged to someone else. The state presented evidence that the money came from an illegal source, and that's different.
The evidence that I was arguing was that it's not his money. Not only did he not know how much he had, it smelled like marijuana, and he doesn't use marijuana. I also was mentioning how it was packaged. It's in a
Let's say that he was a marijuana dealer and engaged and had just completed a transaction for the sale of 500 pounds of marijuana and buried the money in there just to make sure it smelled like marijuana. How does that refute ownership?
In that case, if that was our position and we were conceding ownership, he would have standing. I wouldn't be saying he doesn't have standing if he's saying, it's not like we said he doesn't get to keep his dirty proceeds. We were saying they're not even his proceeds. And the court also did not, it would be problematic if the court had said, I find that these are dirty proceeds, he doesn't even get to keep them, he has no standing. But that's not what the court said. The court appropriately considered 4310D and said, I find he has not presented evidence of ownership, that I find him to be uncredible. And he went through 7 reasons why he thought he was uncredible. And they're saying that, he was using those for the drug trafficking purposes. But if you look at the language the judge used, he says, before he lists these factors, claimant testified this cash was his own money. The testimony is not believable for several reasons. And the court went through the 7 reasons that it found he was not credible. So the court was zeroing in on ownership like it's supposed to according to 4310. It didn't conflate them. It zeroed in on ownership and it evaluated credibility. And I think the trial court should be given the discretion on credibility as long as there's substantial evidence. And here, I think the judge pointed out substantial evidence when he was evaluating the defendant's credibility. And that's what this case comes down to, in my opinion, is does the trial court have the discretion to consider credibility? Because he didn't conflate the issues.
So what we're looking at then, under your view, is a conclusion that the claimant did not even meet a burden of production on ownership, that he was so incredible that the state bore no burden at all because claimant hadn't even passed the minimal threshold for the burden of production on a preponderance standard. Is that your theory?
No. Because after this ruling, the state had to submit an application for judgment of forfeiture and still demonstrate probable cause that the court subsequently grants. I don't
think that's an answer to my question. You have transformed this argument now into one where we should defer to the court's credibility finding. And I'm trying to understand what that credibility finding relates to. It seems to me that your suggestion, if the issue is Mr. Johnson's credibility, then it seems that your suggestion means that we have to find that Mr. Johnson was so incredible and the court found him so incredible that he didn't even meet a burden of production.
Well, the standard wasn't burden of production. The standard was more likely than not that he's the owner. And he didn't meet that burden. And that's what the court went through and gave the reasons that he didn't meet.
But the court never said it's more likely than not that someone else is the owner.
They did.
Where?
It says is that the 2 possibilities was what was argued was it's his money or it's not his money, because that's what the state was arguing. And they said, as between these 2 possibilities, that he flew with his own cash to buy the truck or he's transporting the proceeds of drug transactions clearly.
But the second one doesn't say it was someone else's.
Let me ask you one question, counsel, going off of Judge Swan's question. Okay, so you have conceded that Jerry would be the owner if these were his tainted proceeds, and he was upstream and downstream, a vertically integrated drug dealer. Okay. Now, what factor that you have identified, and I've heard 3, makes that distinction between a mule and a vertically integrated drug dealer?
The testimony at the hearing from the detective discussed the mules and how their flight patterns, how they often don't know how much they
And
have.
that rules out that it was his drugs.
Oh, that it was his proceeds?
Well, that's what you have to get there, don't you?
Yeah, well, when you look at the factors that were considered by the court, and you looked at the things that were argued by the state, because you also had, I know these, I don't want to restate the same facts that I had said earlier, but there was also, he had different explanations at the airport than he did at the hearing.
And that's different if it's a drug mule or someone who is a full-service provider, both transportation and drugs.
Maybe not. Maybe because they're both going to lie. So maybe not. Like they could both think, in one scenario it could be the actual drug traffickers, and in one situation it could not. But here, there was enough evidence that he wasn't even the owner of it. And I think that's what the trial court specifically found.
All right.
I know I'm over time.
So if you have a full-service drug dealer, picture your favorite TV show about drug dealers, right? And your favorite drug dealer is manufacturing and distributing drugs on a massive scale, totally unlawfully, and makes millions of dollars. Does that person own the money?
I would say yes.
Okay. What's different? Let's assume that every unpleasant inference that you could draw about Mr. Johnson is true. What's different between that hypothetical and Mr. Johnson's case?
All the evidence that he's not the owner, being this is a person who has a trucking company, who has these business bank accounts, and there's no bank record of it. And then even that other money that he says he got from another source, is there at least a bank record? I mean, this guy uses banks. Is there a bank record of that other source that he got from his uncle? No, because he says he kept it in cash and he commingled it with all the other money, so there's no bank record.
All right.
And
I don't think you're answering my question, and we're over time, so let me turn to rebuttal.
Thank you, Judge.
Your Honors, the government got it exactly right in his first statement. The court initially stated the correct burden, and it initially applied the correct burden. Even after Jerry was cross-examined by the government, the court held that Jerry had clearly established his interest in the property and that no other evidence should be put on regarding standing. After being cross-examined, the court found Jerry to be credible and that his statements were more than sufficient to establish standing. But then the court went on to hear evidence of probable cause, and it allowed that evidence to infect the court's ruling. As your honors have pointed out, there are 3 factors that are relevant to the low threshold of the standing inquiry. 1, did they timely file a sworn claim? That Jerry did. Under the penalty of perjury, Jerry filed a sworn claim, and he was not impeached on the statements he made within that claim. The money was taken directly from his person. And finally, there is no other owner. There is no other claimant to the property. The government did not offer any evidence to even suggest that there is another person who would own the property. The standard for the court is substantial evidence. It must have substantial evidence that Jerry was not the owner of the property that he claimed was his. And he did not find substantial evidence to support that conclusion. Your Honors, there's been a lot of questions about was there evidence that the money belonged to someone else, but when Detective DeSantiago was expressly asked, and I'm on page 75 of the transcript, Your Honor, did you find any evidence of drug trafficking by Mr. Johnson? Detective DeSantiago said no, not on that date. There was no evidence that Jerry was engaged in drug trafficking, that the money belonged to someone else. Your Honors, if Jerry did not meet his burden when he satisfied the 3 Volstrom-Benson factors and the government did not dispute those factors, then no one traveling with cash can ever meet their burden of establishing ownership. Your Honors, because the court improperly conflated the 2 standards and found that Jerry was not the owner of the property that was taken directly from his person because it was more likely that he was engaged in criminal activity in violation of 4310D's standing requirement, respectfully request that you vacate the Superior Court's ruling and remand for further forfeiture proceedings.
Thank you, counsel. The matter is now under advisement. The court will issue a written decision in due course, and the court stands adjourned.